A new bill in Congress could fundamentally change how naturalized citizens lose their citizenship. If you're a naturalized U.S. citizen, what you're about to hear might concern you. This isn't about what you did to become a citizen anymore. This is about what happens after. Stay with me because this affects millions of Americans. Welcome back to U.S. Info Updates, where we break down complex immigration news into information you can actually understand and use. I'm here today to discuss something that's generating a lot of anxiety in immigrant communities across America, the Fraud Accountability Act. This bill was recently introduced in both the Senate and the House of Representatives, and it represents a dramatic shift in how the government approaches citizenship revocation. Now, before we dive deep, I want you to take a breath. There's a big difference between a bill being introduced and a bill becoming law. I'm going to explain exactly what this legislation proposes, walk you through the serious legal problems it faces, and give you my honest assessment of whether you should be losing sleep over this. If this is your first time here, make sure to subscribe and hit that notification bell so you don't miss critical updates that could affect your immigration status or that of your loved ones. Understanding current denaturalization law. Let me start by explaining how denaturalization works right now, because understanding the current system is essential to grasping why this bill is so controversial. Under existing law, the government can strip someone of their U.S. citizenship only for issues related to how they obtained that citizenship in the first place. This typically happens in two scenarios. First, if there was a technical or procedural error in the naturalization process, meaning someone was granted citizenship when they legally shouldn't have been. Second, and more commonly, if someone committed fraud or made material misrepresentations during their naturalization application process. The key word here is during. Everything hinges on conduct that occurred before or while becoming a citizen. Once you're naturalized, your actions as a U.S. citizen might subject you to criminal prosecution, just like any other American, but they cannot be grounds for revoking your citizenship. Your citizenship, once properly obtained, is permanent. This principle isn't arbitrary. It reflects a fundamental understanding in American law that citizenship is not conditional. You're either a citizen or you're not. There's no probationary period. There's no citizenship light. This protection exists because our legal system recognizes that the ability to revoke citizenship creates a two-tiered system where some Americans have more secure status than others. What the Fraud Accountability Act actually proposes now, the Fraud Accountability Act completely upends this framework. Let me walk you through the major provisions of this bill because the details matter enormously. First, and most significantly, this legislation would allow denaturalization for fraud committed after someone becomes a U.S. citizen. Read that again. Not fraud in obtaining citizenship, fraud committed as a U.S. citizen. This represents a fundamental reimagining of what denaturalization means. Instead of being a corrective measure to undo improperly granted citizenship, it becomes a punishment for criminal conduct by citizens. Second, the bill removes denaturalization from civil court and places it directly into criminal proceedings. Under this proposal, when someone is convicted of fraud in criminal court, that same court would be required to immediately initiate denaturalization proceedings. The citizenship revocation wouldn't be a separate civil process. It would be part of the criminal sentence. Third, and this is where it gets particularly concerning, the bill uses mandatory language. It states that judges shall denaturalize someone convicted of fraud. Not may, not can consider, shall. This means judges would have no discretion, no ability to weigh individual circumstances, no room for mercy or proportionality. Conviction equals denaturalization automatically. Fourth, the bill eliminates the $10,000 threshold for fraud. Currently, for fraud to be considered an aggravated felony that triggers immigration consequences for green card holders, it generally needs to involve more than $10,000. This threshold exists to distinguish between serious fraud and relatively minor offenses. The Fraud Accountability Act removes this distinction entirely. Any fraud, regardless of amount, would qualify. Fifth, And this affects not just citizens, but permanent residents too. The bill applies deportability provisions to naturalized citizens. This is extraordinary from a legal perspective. Deportability sections of immigration law have always applied to non-citizens. The concept of deporting a citizen is fundamentally contradictory, yet this bill attempts to bridge that gap by using denaturalization as a pathway to make citizens deportable. Finally, the bill includes retroactive application going back to September 30th, 1996, nearly 30 years. Anyone convicted of fraud since that date could potentially face denaturalization proceedings under this law if it passes. Think about that. Someone who committed a fraud offense 20 years ago, served their time, rebuilt their life, could suddenly face citizenship revocation. Who this bill would impact. The implications are staggering when you consider who could be affected. We're not just talking about major fraud schemes involving millions of dollars, though those would certainly be covered. We're talking about any fraud conviction. Consider someone convicted of tax fraud involving a relatively small amount, or someone who committed welfare fraud, or someone who lied on a loan application, or engaged in any of countless scenarios that could technically constitute fraud under federal or state law. Under this bill, all of these would trigger mandatory denaturalization if the person is a naturalized citizen. The daycare fraud scandal that prompted this legislation involved serious misconduct that defrauded government programs. Nobody defends that kind of fraud, but this bill goes so far beyond addressing that specific situation. It creates a sweeping mechanism that could affect thousands of naturalized citizens for offenses that natural-born citizens would face through the criminal justice system without any threat to their citizenship. The constitutional problems. Now, let's talk about why this bill faces enormous legal obstacles. I'm going to discuss two Supreme Court precedents that present nearly insurmountable challenges to this legislation. The first is Afroyim versus Rusk, decided in 1967. In that case, the Supreme Court held that Congress cannot take away a U.S. citizenship unless that person voluntarily renounces it. This was a landmark decision that established citizenship as a constitutional right that cannot be stripped by legislative action. The Fraud Accountability Act attempts to do exactly what Afroyim prohibits: create a statutory mechanism for involuntary denaturalization based on post-citizenship conduct. The second critical precedent is Schneider versus Rusk from 1964. This case established that naturalized citizens possess the same rights as natural-born citizens, with one exception: eligibility for the presidency. The court held that creating different classes of citizens with different rights violates equal protection principles fundamental to our Constitution. The Fraud Accountability Act explicitly creates two classes of citizens. Natural-born citizens could commit fraud and face criminal penalties, but their citizenship would remain secure. Naturalized citizens committing identical offenses would lose their citizenship. This is precisely the kind of differential treatment that Schneider prohibits. Some might argue that naturalized citizenship has always been revocable in ways that birthright citizenship is not, which is technically true, but that revocation has always been tied to fraud in obtaining citizenship itself. Once citizenship is properly obtained, both naturalized and natural-born citizens have been treated equally regarding their status. This bill breaks that principle by making naturalized citizenship conditionally permanent based on future conduct. Why this bill likely won't become law? Let me be clear about my assessment. I do not believe this bill will become law in its current form. And if it somehow does, I believe it would be struck down by federal courts relatively quickly. First, there's the political reality. Many bills are introduced in Congress as responses to current events or to demonstrate action to constituents. the vast majority never make it out of committee. They're symbolic gestures or negotiating positions rather than serious legislative proposals. Given how dramatically this bill would reshape fundamental aspects of citizenship law, it would require overwhelming support to pass both chambers and receive presidential approval. That level of consensus seems unlikely, especially given the constitutional problems. Second, even if political circumstances aligned and this bill somehow passed and was signed into law, it would immediately face legal challenges. Civil rights organizations would undoubtedly file suit before the ink dried on the president's signature. Given the clear precedents in Afru and Schneider, lower courts would likely issue preliminary injunctions, blocking implementation while the cases proceeded. Eventually, the Supreme Court would need to either overturn its own precedents or strike down the law. Third, consider the practical implications that would emerge if this law were enforced. You'd have judges forced to denaturalize people for minor fraud offenses with no ability to consider whether the punishment fits the situation. You'd have people who committed offenses decades ago suddenly facing citizenship loss. You'd have the government attempting to deport people to countries they haven't lived in for 40 or 50 years. The human consequences would be severe, and the implementation challenges would be massive. The broader concerning trend. That said, while this specific bill likely won't become law, it represents a troubling trend that does concern me as someone who has worked in this field. There's an increasing movement to treat denaturalization like deportation, to use immigration consequences as additional punishment for criminal conduct by naturalized citizens. This represents a fundamental misunderstanding or perhaps a deliberate reframing of what immigration law is meant to do. Immigration law governs who can enter and remain in the United States as a non-citizen. It's civil, not criminal. Deportation is not punishment for a crime. It's a consequence of losing legal status to remain in the country. Citizens, by definition, cannot lose their legal status to remain in the country. They have an absolute right to be here. When we start talking about denaturalization as punishment for crimes, we're turning immigration law into an extension of the criminal justice system, specifically for naturalized citizens. We're creating additional penalties that apply only to some Americans based on how they acquired citizenship. That's not how our system is supposed to work. The criminal justice system already has mechanisms for punishing fraud, prison sentences, fines, restitution to victims, probation. These penalties apply equally to all Americans, regardless of how they became citizens. If we decide that current penalties for fraud are insufficient, then we should increase those penalties for everyone, not create a separate, harsher regime that applies only to naturalized citizens, what you should actually worry about. So, if you're a naturalized citizen watching this video, what should you take away from all of this? First, don't panic about this specific bill. Seriously, the likelihood of it becoming law is very low, and even if it somehow did, it would face immediate legal challenges that would very likely succeed. This is not something to lose sleep over tonight. Second, do stay informed about immigration policy generally. Subscribe to channels like this one that track these developments. While this particular bill is unlikely to become law, immigration policy is constantly evolving, and being informed helps you understand your rights and any real changes that might affect you. Third, if you have any issues in your past related to your naturalization application, whether you think they're significant or not, consider consulting with an immigration attorney who has experience with denaturalization cases. I'm not trying to scare you, but it's always better to be proactive than reactive. Most people have nothing to worry about, but if you do have concerns, professional advice is valuable. Fourth, recognize that your voice matters. If legislation like this concerns you, contact your representatives. Let them know your perspective. Congress responds to constituent input. Many members may not fully understand the implications of bills they're asked to support. Your story and your concerns can make a difference. The Fraud Accountability Act represents a dramatic proposal that likely won't survive constitutional scrutiny, but it's part of a broader conversation about citizenship, naturalization, and what it means to be American. These are important discussions, and I'm committed to keeping you informed as they develop. If you found this analysis helpful, please give this video a thumbs up and share it with anyone in your community who might be concerned about these issues. Drop your questions or thoughts in the comments below. I read every comment and often create follow-up videos based on what you're asking about. Remember, knowledge is power, especially in immigration matters. Stay informed, stay engaged, and don't let fear drive your decisions. Until next time, this is US Info Updates, helping you navigate the complex world of American immigration.